I beg to mention item number 5 and 6. Kindly adjourn the matter for a week.
Five.
Five.
I am appearing, Lordship.
You are seeking adjournment on behalf of whom?
In behalf of J. Paul. 6, item number 6. She has some throat infection.
Okay, 5 and 6 are connected.
Yes,
Lordship.
yes.
Where's when do you-
Co-accused, they are
Co-accused.
co-accused, Lordship.
And when do you want, madam?
Next week, any day.
Next week, okay.
Next Tuesday.
Okay. A prayer for adjournment has been made
Next week.
on behalf of Ms. J. Paul, Leonard, counsel for the appellant in criminal appeal 10 of 2023. Also heard Ms. D. Borpujari. You are legal aid counsel,
Lordship.
Leonard legal aid counsel, appearing for the appellant in criminal appeal J 34 of 2023, as well as Ms.
His name be
As well as Sri R. Kaushik, Leonard APP Assam Para. Matters accordingly stand adjourned to be listed on Tuesday next.
Okay.
Obliged.
May I please, I beg to mention item number 8, my lord.
Stand, huh? Yes, item number
8, my lord. Can this matter be taken at the first week of March, my lord?
first week of
March,
item number.
item number 8, my lord.
You're on behalf of the appellant. Okay.
Yes, my lord.
On a request made on behalf of the appellant, matter is adjourned to be listed on. Yes, when?
First week of March, my lord.
On 5th of March,
My lord.
5/3. Madam, you'll be appealing.
Lordship.
Ms. B. Bhuya, Leonard APP is present.
Obliged, my lord.
May I please, Your Lordship, I beg to mention two criminal appeals, Lordship.
What stage?
IA is pending, Lordship, for orders.
What is the IA for?
IA for appeal against conviction, Lordship.
IA for?
IA for
You should know about the facts.
Suspension of sentence?
Lordship.
Bail for bail? I is for bail?
Bail.
When was it last listed?
5th of May 2025.
Okay, we'll have it on Friday next.
Right. Plus.
May I please, Your Lordship? I beg to mention item number 2, Your Lordship.
Hmm.
We intend to file a written objection, Your Lordship. So we need an
You're for whom?
for Mr. J. Pine.
Okay.
For at
You
least
have
2 weeks.
informed the other side
Yes, Your Lordship.
on a request made on behalf of the Home Department. 2 weeks' time is granted to enable filing of objection. List we give a date, madam. Ms. D. Ghost, Learned Counsel for the applicant is present. Para list on the 17th. We'll have it on 6th of March. 6th March. You file it before them. Before that, yes.
My Lordship, I beg to mention one review petition, my Lordship. I have filed, my Lordship. Can it be fixed?
Before which court?
Before this court had dismissed this matter, my
This division bench.
division bench.
Thi-
FT matter, my Lordship.
This division bench.
Yes, my Lordship.
Did we?
On 18/12/2025.
Okay.
1 week we have.
18 May
No, no,
2025.
18/12.
12.
18/12/2025. 18 December 2000.
When did you file the review?
Yesterday, my Lordship. I have to collect some documents. It is,
You can move, we can grant you permission, but this bench is will be there till tomorrow, I think. Tomorrow you can move.
Not tomorrow, today.
Call it again.
can it be on next week or
Next week,
March
we cannot say this bench is not there.
or on March?
We cannot fix a date. We do not know the availability. You can move it tomorrow if you want. Tomorrow this bench is there. Next week onwards this bench will not be.
Tomorrow, then.
Tomorrow if you want. What grounds are you seeking review?
My Lordship, regarding that, there are certain grounds are there, my Lordship. Regarding one of his family member has already declared
And
India.
how do you explain the delay in filing the review?
But there are holidays were there, my Lordship. Plus, I have to collect certain documents which are.
Have you filed any application for condonation?
Yes, my Lordship.
That notice has to go then. You can move it tomorrow.
Item 11, subdivisions.
May I please, your lordship. The appeal against conviction, lordship, here the appellant is sentenced under section 6 of the POCSO Act.
You're a legal aid counsel.
Yes, lordship. I'm sorry, lordship, yesterday I missed the case.
Conviction is under
Section 6 of the POCSO Act, lordship. Sentence
POCSO.
POCSO. For rigorous imprisonment for 20 years.
Is the
20 years.
microphone on or not?
20
on
years, right?
It's under section 6.
Who is the respondent number 2?
On number 2, my lord, I'm appearing as a legal.
The informant part.
You have already appeared.
In the IA, he appeared.
IA,
lordship. There was an IA for.
There was an IA
Yes,
IA.
for D.
for condoned that has
For
been
the-
heard. Miss LDB, learned legal aid counsel, appearing for the appellant. First of the instant appeal has been filed under so and so, against so and so. Admit, para, call for the records. Miss B. Bhuya, and Miss Saloy, R. Saloy, Miss R. Saloy, learned counsel assisting Miss B. Bhuya, learned DPP accepts notice on behalf of respondent number 1. Sri P. Sekya, learned counsel, accepts notice. Now, learned counsel who had earlier appeared at the stage of IA for condonation of delay for the respondent number 2 has accepted notice on behalf of the respondent number 2. Accordingly, the requirement of issuing formal notice is dispensed with. Para, list after receipt of the TCR.
Lies.
Reflected in the.
The raised to reflect the name of Sri P. Sekya, learned legal aid counsel for the respondent number 2.
Must be. Item 1.
My lord, in this matter, the IA is filed for my suspension of sentence and the release of the petitioner on bail. But TCR has not been received. My lord, I think for consideration of the IA, that TCR is required. My lord. TCR has not been received.
TCR, answering.
It's not come, no? As per your instructions,
Yes.
as per your information, it's not
Yes,
come.
my recording has taken the record.
Heard Sri M.J. Kadir, learned counsel for the applicant appellant. Also heard Ms. B. Bhuya, learned APP. And you are also appealing, Mr. Ahmed, H. Ahmed, for this one number 2. Para, the learned counsel for the applicant has submitted that for better appreciation of the IA, the records, perusal of the records would be necessary. First stop. We have noted that the records have already been called for in the connected appeal, which however have not been received. Para, list immediately after receipt of the records.
Item 3.
We reviewed.
May I please, lord?
Yes.
Okay, we have prepared this review petition, my lord, for an error, my lord, relating to Article 22(5), my lord.
What is the error?
Error was, my lord, we filed one representation which was received by the
Mr.
forwarded-
Those are matters of on merits. You
My
take
lord-
up this matter in appeal, not a ground for review.
my lord, actually, this is under 22(5), my lord. That is why I have,
This,
we have
this,
prepared
this
this.
can be an argument on merits.
No, my lord, in preventive detention cases, my lord,
We have passed an order on merits. You are aggrieved, you can file an appeal.
My lord, we understand, but when, my lord,
We are not
when-
entertaining.
when, my lord, it relates to our constitutional error, my lord,
This is not an appellate court.
my lord, we understand.
Your constitutional rights, you can hesitate in an appellate court. We have expressed our opinion on merits. If you are aggrieved, you take remedy.
My lord, that representation, which was forwarded on 27 July and was received on 13 August.
Mr. Rahman, we cannot go on the facts again. You show us an error apparent on the face of it.
My lord, that representation, about that representation, my lord, in the judgment, my lord, not a single whisper is there, my lord.
We are
It
dismissing this.
directly
We are
relates
dismissing.
to
We are dismissing.
Article 22(5), my lord.
Sri M. Rahman, learned counsel for the petitioner who has filed this instant petition for review of the judgment and order dated 17/12/2025 passed in the connected WPC Criminal 61 of 2025. Full stop, para. The learned counsel has urged that in the impugned judgment, in the said judgment, there is no mention about the representation alleged to have
Para 10,
been,
my lord.
alleged to have been filed. Full stop. Para. We are, however, of the opinion that the judgment has been passed after consideration of all the facts and circumstances, and the issue presently sought to be raised in the form of a review can at best be a ground in an appeal. Full stop. It is a settled position of law that the powers to be exercised by a review court is not the powers to be exercised by an appellate court. Para. We are of the considered opinion that no case has been made out which would fulfill any of the requirements of maintaining a review petition. Full stop. The review petition is accordingly dismissed.
My lord, may I submit, my lord, one thing, last, my lord, that my lord has in various.
Mr. Rahman, we have passed the order. Go for the appellate court. Yes, next.
May I please introduce my lord? My lord, this IA was filed for my lord's condonation of delay of 35 days, my lord. Yesterday, my lord, they appeared under side. My lord, I have stated the grounds, my lord. Para 6, my lord. Not only 35 days, my lord.
Yes, Mr. You will not have any objection?
Regarding delay, I have no objection, but my lord, one thing is to be considered that there is an outstanding amount, ADR amount, that is.
We'll consider at the time of,
My lord.
okay, we'll contend the delay.
My lord.
Third, Sri A.H. Laskar, learned counsel for the applicant appellant who has filed this application under section 5 of the Limitation Act 1963 for condonation of delay of 45 days in preferring the connected appeal. Full stop. The appeal has been preferred against judgment and order dated so and so passed by so and so. Para. When this matter had come up for consideration yesterday, Sri S. Alim, learned counsel, had appeared and submitted that he would file the wakalatnama for the respondent, for the sole respondent. Para. Sri Alim has submitted that that the respondent number 1 would not have serious objection to the aspect of condonation of delay. However, he has informed that the maintenance amount has not been paid. Para. The causes shown for condonation of delay as stated in the petition.
Para 6,
More-
my lord. Para 6, my lord.
More particularly in paragraph 6 and 7 have been perused. Para. It is a settled position of law that while adjudicating an application for condonation of delay, there is a requirement to have a pragmatic and justice-oriented approach. We have also noticed that the delay is not inordinate. Para. In view of the above, the delay of 45 days in preferring the appeal stands condoned. IA stands allowed. Para? The mat appeal may be registered and displayed for admission in the next week.
My lord, my humble submission, since my lord, there is a time limit given by the family court to pay the added amount. My lord, can my lord, if date may be fixed, my lord.
It has to be registered.
My lord,
Maybe next week.
Mine.
Next week also.
Next week.
Next
my
week.
lord, much obliged. Obliged, my lord.
Item 4.9.
মানে পাঁচশো ব্যাপারে টাইম দিন মানে ডিভিশন লেন্স না নেবে
Timing. Timing will be difficult. If we start some other matters, timing will be difficult. Let us see. It's next.
Item 7.
Mr. Mazumdar?
Lordship.
Yes, who will be your on the.
Lordship, Azahar at peaceful.
Yeah,
For Azahar,
Just give us 2 minutes.
Lord.
Conviction under
Section 302,
302.
Lordship.
Two persons died or one person?
One person died and injured during the pendency of the trial also expired.
No, he died naturally or he died as a result of the injuries.
I think during trial, it may be or may not be Lordship, but
But this was lodged in 2015.
Lordship.
It may not be as a result of the injury.
Mm.
Maybe we do not, but
Okay.
we are primarily, the charge is against causing death to the husband of the informant.
Lordship. And 326 and 307 in respect of injured.
The brother-in-law.
Lord.
And the accused is the son,
Son of the
Brother-in-law.
injured witness.
brother-in-law, the
Lordship, Lordship.
nephew of the deceased.
Lordship.
Strange. What is the name of the deceased?
This is the Alimuddin Lashkar and
Okay.
injured witness,
No, that
victim-
was seen, but Alimuddin name is not written in the Ejar.
Lordship, but she stated her husband.
No, understood, but name as such has not been
No,
given.
no, Lordship.
His name is Alimuddin.
Lordship, his name is Alimuddin.
Alimuddin Laskar.
Alimuddin Laskar.
Accused, one person faced trial, right? Only one person.
Lordship.
The appellant.
Yes, please.
Lordship, Ezaharet Face Court.
26/7,
May I, Lordship, may I?
26/7/15.
Lordship, 26/7/15. It was lost at 11:30 p.m. May I read, Lordship? I have the honor to state that around 5 p.m. today, that is on 26/7/2015, Sunday, while my husband and my brother-in-law, Islamuddin Lashkar, are having a conversation beside the road near Altaf Hussain's pharmacy, situated at Chokala Digi. The above mentioned accused suddenly came riding a motorcycle, and after stopping the motorcycle next to my husband, he took out a long towel from his waist and attacked my husband all of a sudden and started hacking my husband with dowel in his hand. As a result, my husband died on the spot. Being helpless, my brother-in-law, who was with my husband, rushed to Altaf Hussein's pharmacy. Then the accused also went to the pharmacy and hacked my brother-in-law, who is the father of the accused. And after causing grievous injury to him, the accused immediately fled therefrom by his motorcycle. At present, my brother-in-law is battling with life at Silchar Medical College and Hospital. The witness will prove the fact during investigation. I therefore pray to you to investigate the matter and take necessary action against the offender. So in this
Yes.
case, Lordship, learned trial court relied heavily on PW2 and 10. It was the findings of the learned trial court that PW2 and 10 appears to be eyewitness. So, Lordship, in the Lordship, Ezahar, there is a no mention that someone has witnessed the occurrence or informant herself witnessed the occurrence. That was not stated. Lordship, kindly come to
Did Islam, was Islam in a position to appear as a witness?
Lordship, at the relevant time, he was hospitalized, injured witness, but his statement could be recorded by the.
No, was it, did he appear as a witness?
No, no, no.
He was,
No, no.
he was
During
not a-
trial, he expired. That's why,
now when did he pass away?
Lordship, date is not in the record. So I'm.
Okay. But was his statement recorded by the police?
That is also not witnessed in the whole of the evidence.
And what about the IO?
I also know here his part, whether his statement was recorded or not. That was not stated.
Why we are asking? Because this Islam was at the site,
Lordship.
at the place of occurrence. He was himself injured.
Injured eyewitness.
So his the
Lordship.
veracity of his deposition or his statement would be more.
Lordship, only PW4, who stated that his father, injured witness, stated him that one person who was who with a covered face attacked them. But that was not stated. That witness was declared hostile by the prosecution. He was cross-examined. So he is evidence, Lordship, in that way. So, Lordship, kindly have a look at the evidence of informant.
Let us go serially.
Lordship, informant at page 9, Lordship, PW1.
Informant.
Lordship. May I read, sir?
Yes.
About 2 years back, in the month of শ্রাবণ, in a day at about 5 p.m., I was in my house, and at that time, on hearing hue and cry towards west of my house, that is near pharmacy of one Altaf Hussain, I went to that place and found my husband Alimuddin was lying on the ground, and I saw cut injury on his neck.
Altaf is 4. Altaf is 4.
Lordship.
He is the pharmacist.
Oh, no, Lordship. He is PW10.
No.
Pharmacy.
Altaf-
Altaf, there are
is
two Altaf.
2 Altaf.
PW4 is the son of the injured witness, and PW10 is the pharmacy owner.
Is it?
Lordship.
Okay. Altaf Hussain Laskar and Altaf Hussain Chaudhary.
So this pharmacy is the pharmacy owner is PW10. The accused person assaulted my elder brother-in-law, Islamuddin, including my husband, in the shop house of Altaf Hussain by accused Zakir Hussain by means of dao. A large number of persons gathered at the place of occurrence, and my son Ruhul Hussain was also present there. My son Ruhul witnessed the entire incident, who reported me about the same. In the said incident, my husband died at the spot, and my brother-in-law Islamuddin also sustained injuries in his right hand caused by dao. When the people started to assemble at the place of occurrence, the accused left the place by riding a bike. I lost the azahar on the date of occurrence to police, putting my thumb impression. Thereafter, postmortem examination was held on the dead body of my husband. My brother-in-law got medical treatment at SMCH Silchar. Police recorded my statement. My house is situated at a distance of 4 knolls away from the national.
What is this knoll? How much?
Knoll, it is a local unit of measurement.
understood.
Barakbuli.
Yes.
1 knoll implies 12 feet. Lordship.
12 feet.
12 feet.
But it is very near.
Very near.
36 feet.
36.
36 feet.
Lordship.
Are you sure? One knoll is 12 feet.
I'm sure. I have searched on, yes, yes.
12 feet.
12 feet.
12 feet.
Is it so near? 4 knolls, houses from the pharmacy.
So, Lordship, this is he stated.
Okay.
And this witness of
Have you checked the?
Lordship, I have searched for local people of
Okay, one knoll is 12 feet.
Lordship, it is 12 feet. It may be, Lordship, but from the people I have gathered the information.
Approximately 12 feet.
Approximately 12 feet.
Madam, just recheck.
National Highway at Shokalarpar. It is not a fact that my house is situated at a distance of about 2 kilometers away from the said National Highway. And there are other houses in between my house and the National Highway. It is not a fact that distance between the place of occurrence and connecting point of our path to the National Highway is 300 to 400 meters. When I arrived at the place of occurrence, I found about 100 local people there, but I cannot say the names of those persons. On the date of incident, Ruhul Hussain went out from the house about 1 to 2 hours before the incident, and at that time, I was in the house. I cannot say who informed police about the incident, but police came to the place of occurrence after the incident. I accompanied the dead body of my husband to the police station at about 6 p.m. on the date of incident. There were other persons, including my son, who accompanied dead body of my husband to the police station. On reaching at the police station, we lost the azahar, and thereafter I came back to my house. I did not witness the incident. I found the accused Zakir Hussain amongst the crowd at the place of occurrence. I know the contents of the azahar as the same were read over to me. It is not a fact that in the azahar as well as in my statement before police, I did not mention that when I reached the place of occurrence. I saw accused Zakir leaving the place of occurrence, being armed with dao in a motorcycle. The gathered person did not obstruct Zakir Hussain while he left the place of occurrence. It is not a fact that I did not mention in my Azahar as well as in my statement before the police that I came to know about the incident from my son Ruhul. And when I came to the place of occurrence, I saw cut injuries on the neck, face and head of the body of my husband. And the said fact is not true. I cannot say as to who shifted my brother-in-law to the hospital. It is not a fact that I have falsely stated that I saw cut injuries on the person of my brother-in-law. My said brother-in-law reside in a separate house. The paternal properties of my husband was amicably partitioned but not partitioned formally. I cannot say whether there was any dispute regarding the land between my husband and my injured brother-in-law. It is not a fact that I have deposed falsely that the accused committed the crime as alleged by me, and he did not leave the place of occurrence in a motorcycle as he has no motorcycle. Accused Zakir is the resident of Lalachera Ghat. I cannot say the distance of in km between the house of the accused and my house. I know Altaf Hussain Chowdhury, the owner of the pharmacy. PW2, Lordship alleged eyewitness, son of the informant,
Ruhul.
Lordship, as well as
But here, please come back to page 10,
Lordship,
the middle part,
Lordship.
the middle part, page 10. I did not witness the incident. Have you got it? Page 10.
Lordship.
Yeah, she's not.
No. I did not witness the incident. In the middle part.
Lordship, but
Have you got it? Just at the center of the page 10. I did not witness the incident. I found the accused.
I did not witness. Lordship, I got
I found the accused Zakir Hussain among the crowd at the place of occurrence.
place of occurrence.
So these are coming at the cross-examination stage. Then
Lordship.
I know the contents of the Ajahar as the same were read over to me. Then what is this?
It is not
It is not a fact that
that
in
the
the
Azahar,
Ajahar,
as
as
well
well as my
as
statement
in
before
my
the police,
statement before police,
I
I
did
did
not
not
mention.
mention that when I reached the place of occurrence, I saw accused Zakir leaving the place of occurrence, being armed with dao in a motorcycle.
Now, this statement, do you find in the Ajahar
No.
or in the deposition?
It is only in the
Let us see the originals in a process.
No, even in the deposition,
Lordship, in the Azahar, this line is not there.
and then even in the chief examination, it's not
Chief
there.
also not there.
Why was this put to her? There's no requirement to contradict her.
Put to her out of context and she denied.
Not requirement. It was my.
Okay.
In the chief, she did not say that I saw the. Then you can put a question to her. That in the police statement you did not say. Then the denial might come to contradict. Since there was no statement in the chief, it was not a proof fact. I don't know why this question was put. Nonetheless, please go ahead. Yes, next.
Lordship, page 12, PW2, on 26/7/2015 at about 5 p.m., I was in the National Highway at a distance of 3 nulls away from the place of occurrence. There was one pharmacy of Altaf Hussain near the place of occurrence. At that time, I found Zakir Hussain Lashkar, who was
He is Rubul or Ruhul?
Lordship, it is here it is Rubul Hussain.
But mother said Ruhul.
Lordship. And somewhere it is Ruhul, and in the deposition it is Rubul Hussain.
He has signed as Ruhul or Rubul. Just see the signature.
Original.
See the signature is there on the left side.
Lordship, it is Rubul Hussain.
Oh?
Rubul. Ruhul. Ruhul Hussain.
Ruhul Hussain. H.
It is H, Lordship.
H B যেন হয়ে পড়ে B হয়ে পড়ে
No, looks like H.
H H B হয়ে পড়ে
Both.
I think it's B Rubul
It doesn't look like B.
B H এখানে লেখে B এনেকে লেখে না
No, I think it's
No, no.
anyway. No, it's Rubul, I think. Second page more clear. Anyway.
Okay, doesn't matter. Yes.
Lordship, at that time, I found Zakir Hussain Lashkar, who was coming from Lalachara in a bike, and he stopped near the pharmacy. At that time, my father and my uncle Islam were there. Then the accused Zakir Hussain Lashkar arrived at the spot with a dao, taking the same from his bike, and at first he gave a dao blow on the head of my father, and as a result, my father fell down on the ground. By that time, my uncle Islamuddin went to the pharmacy of Altaf Hussain, but the accused rushed to the said pharmacy and inflicted dao blows on him too. And thereafter, the accused came out of the pharmacy, and thereafter, the accused found my father elite, and as such, he also gave more dao blow on the neck of my father, and as a result, my father died at the spot instantly. By that time, many people assembled there, and then the accused left the place of occurrence in his motorcycle. Immediately after the incident, my mother and my brother and sister came to the place of occurrence, and I told the entire incident to my mother. Thereafter, police came to the spot and took the dead body, and myself and other also narrated the incident to police. Exhibit 1 is the inquest report, wherein Exhibit 1.1 is my signature. My uncle Islamuddin was shifted to SMCH Silchar for his treatment, who sustained cut injuries on his cheek, right hand, and back. By Exhibit 2. Similarly, police seized on blood-stained white half kanji, one blood-stained lungi, one blood-stained white Punjabi. Thereafter, the PM examination on the dead body of my father was conducted at Hailakandi Civil Hospital. When the accused was arrested, the concerned dao was also seized. Cross Lordship. After my arrival at the place of occurrence, other people came there. The incident took place on the public road, and as such, around 100 people gathered there. From the neighboring people, Nasiruddin, Mojaidul Islam, Hafizul Lashkar were present at the place of occurrence. It is not a marketplace, and there was no other shop. The accused fled, except only one shop. The accused fled away from the place of occurrence as soon as he saw the people gathering there. My house is situated at a distance of 150 meters from National Highway. It is not a fact that the place of occurrence is situated at a distance of 500 meters from the path of my house. There are other houses by the side of the path in between the place of occurrence and my house. Police recorded my statement on the date of occurrence at Lala police station. It is not a fact that I did not state before the police that I was on the national highway at a distance of 3-4 knots away from the place of occurrence. It is not a fact that I have stated falsely that I was on the national highway at a distance of 3-4 knots away from the place of occurrence. It is not a fact that I did not state before the police that I found Zakir Hussain coming from Lalachara in a bike and he stopped near the pharmacy. It is not a fact that I have stated falsely that I found Zakir Hussain coming from Lalachora in a bike and he stopped near the pharmacy. It is not a fact that I did not state before the police that thereafter the accused came out of the pharmacy and found my father alive. He gave more blow on the neck of my father, and as a result, my father died in the spot instantly. It is not a fact that I have stated falsely that thereafter the accused came out of the pharmacy and found my father alive. He gave more blow on the neck of my father, and as a result, my father died in the spot instantly. I did not inform police. My mother came to the place of occurrence not on the basis of my information, but after her arrival at the place of occurrence, I disclosed her about the incident. It is not a fact that I did not state before the police that immediately after the incident, my mother, my brother, and sister came to the place of occurrence, and I told the entire incident to my mother. It is also not a fact that I have deposed falsely that immediately after the incident, my mother, my brother, and sister came to the place of occurrence, and I told the entire incident to my mother. After 4 or 5 minutes of the incident, the police came. The distance between the place of occurrence and the house of accused at Lalachara is around 2 kilometers. The Lala police station is at a distance of around 3 kilometers from the place of occurrence. I was there at the place of occurrence for 10-15 minutes after police came. I accompanied my father with police to the Lala hospital and then to the Lala police station. My relative Nasiruddin Barwiya accompanies us to police station. I returned my home at 8 p.m. Thereafter, I did not meet police in connection with the case. One of my uncle Altaf Hussain Lashkar took my uncle to SMCH Silchar. I did not visit SMCH Silchar. It is not a fact that I have stated falsely that my uncle Islamuddin sustained cut injuries. I cannot say when and where the exhibit to Caesar list was prepared and what is the written thereon. I was not present at the place where from the accused person was arrested. I did not see the place where from the police seized the dhow. It is not a fact that I have stated falsely that the police seized the dhow when the accused person was arrested. It is not a fact that I did not see the incident and I do not have any personal knowledge about the incident. I have deposed falsely. It is not a fact that I have deposed falsely that the accused murdered my father and assaulted my uncle in the pharmacy. PW3, one Jahangir Lashkar Lashik. I know the accused person, Zakir Hussain. I know the informant, Aklima Begum Lashkar. She is my aunt. The accused is my related brother. On 26/7/2015 at about 5 p.m., I was in my residence, which is around 500 meters far from the place of occurrence. I am a paralyzed person and could not walk without any support. At the relevant time of incident, I was paralyzed. At the relevant time, I heard hue and cry coming from the old house of the accused person. At the relevant time, in the old house of the accused person, his brother, Altaf Hussain, mother, and other family members used to reside, but the accused was residing in a different house. Altaf Hussain came to my house immediately and told me that his father Islamuddin and uncle Alimuddin were murdered. Then I boarded the auto rickshaw of Altaf Hussain and went to the place of occurrence by the side of the highway near the homeopathy pharmacy owned by one Altaf Hussain Chaudhary. There I saw Islamuddin lying in front of the pharmacy of Altaf Hussain Chaudhary, and his hand was almost severed from his body. I also noticed many cut injuries on the person of Islamuddin. I also saw the dead body of Alimuddin Lashkar, husband of the informant, lying near Islamuddin in front of the pharmacy of Altaf Hussain Chaudhary with cut injuries at the neck, head and other parts of his body. I found many people gathered at the place of occurrence, amongst whom Aklima Begum Lashkar, Ruhul Amin, the wife and son, respectively of the deceased Alimuddin, were there. I did not see the occurrence. From the gathered people, I came to know that accused Zakir Hussain has committed the murder of Alimuddin and caused injuries to Islamuddin. Islamuddin was shifted to hospital. The dead body of Alimuddin was taken by police. Police seized in my presence one bloodstained white color half ganji, one bloodstained blue with mixed white in color check lungi, one bloodstained white Punjabi by material exhibit such and such. It is said Caesar list and exhibit 2 is my signature. Police recorded my statement. Material exhibit 1 is the box containing the seized 3 numbers of bloodstained lotus. Cross. My resident and the resident of Alimuddin are very near, intervened by a house. In both the side of our house, there are houses of many other people. Altaf Hussain, who took me to the place of occurrence by his auto rickshaw, keeping me at the place of occurrence, took the injured Islamuddin to the hospital. From the place of occurrence, I went to Lala Hospital and seeing the injured person, I returned to my home on the same night. I have my own path to reach my home, but Alimuddin does not have any path to reach their home, and as such, they use our path as ingress to their house. The path is 11-12 feet in breadth. My statement was recorded at the place of occurrence on the relevant day. On the next day, police again recorded my statement. It is not a fact that I did not state before the police that Altaf Hussain came to my house immediately and told me that his father, Islamuddin, and uncle Alimuddin were murdered. And then I boarded the auto rickshaw of Altaf Hussain and went to the place of occurrence. I know nothing more about the incident. So, Lordship, from his evidence, one thing it is clear, it is the case of the prosecution that injured witness found in the pharmacy of the PW10. But from his evidence, it is in front of the pharmacy. Lordship, it is that then I saw Islamuddin lying in front of the pharmacy, not in the pharmacy. And I'll
See, this witness lives at a distance of half a kilometer.
Lordship.
By the time he had shifted, he had reached the place of occurrence. The injured person might have been shifted because he was ultimately taken to the hospital.
That also may.
It's a possible thing.
But-
That will not make. But you can urge that this PW3 is not a eyewitness. He is only a hearsay.
Lordship.
He heard from somebody, the people who had gathered there.
Lordship.
That he has said.
Lordship. Lordship, next, PW4. He is the son of the injured witness and he was declared hostile. I know the accused person. Also, I know the informant Aklima Begum, who is my aunt. The accused is my own younger brother. About 2 years back, one day at about 4:30 p.m., while I was returning home in front of pharmacy of Altaf Hussain Chaudhary, I found many people gathered there. I got down from the auto and asked the people as to what happened. The gathered people reported me that my uncle died on the spot and father was still alive with his injuries. Immediately, I took my father to the Lala hospital. There, he told me that one person has assaulted him and his brother, and the person's face was covered by cloths. And as such, he could not recognize the assailant. I found my uncle Alimuddin lying dead on the spot. Thereafter, my father did not disclose me anything about the incident. The prosecution sought permission to cross-examine the witness. The permission is granted.
He was not declared.
But the cross-examination.
No, actually, yeah, he was examined by prosecution, but that thing was missing.
No, but
Okay.
that will be a formality because he's been cross-examined by the prosecution.
It's possible only,
That part is
should
not
also
there.
be written, that's
Yes.
true, but
Should have been it.
cross-examination,
Yes.
only possible by.
It is not a fact crossed by the prosecution. It is not a fact as police recorded my statement and I stated before that my brother Zakir Hussain, in order to kill my father, caused serious injuries in his body by means of dao and kill my uncle Alimuddin. It is not a fact that I have deposed falsely to save my brother from legal punishment. Cross by defense. I did not see the incident. The distance between the pharmacy in front of which the incident occurred and the point from National Highway toward my house is around 500 meters. The distance between that point and my residence is about 500 meters, and there are many shops in between the pharmacy and the point of National Highway. On the other hand, PW2 stated that there are only one shop, that is pharmacy, and there is no other shop. But according to him, there are so many shops. Toward the house is linked. On my arrival, I have found that about 200 people already gathered. There were no local people present there. On my arrival, I did not find any of my family members or relations there at the place of occurrence. I was there at the place of occurrence for 10 to 15 minutes. Thereafter, I started to hospital with my father. I did not find there Aklima and Rubul Hussain. While I was on the way to hospital, I saw that police were going to the place of occurrence. Police went to the SMCH Silchar to record statement of my father. I have stated before the police that my brother Zakir Hussain killed my uncle and assaulted my father. Lordship PW5. Accused Zakir is the brother of my husband. Informant Aklima Begum is my aunt. About 2 years back, while I was at my house, police came and took me to the police station. There I heard that my uncle-in-law was murdered. Police compelled me to put signature on a paper. Exhibit 3 is the Caesar list and Exhibit 3.1 is my signature. While police took me to the police station, there are many people present and assembled people pressurized me to go to the police station. I cannot say the name of all the gathered people. My house and the house of the deceased are at a distance of around 100 meters. At the relevant time, my husband was not in room. I do not know who murdered my uncle-in-law. So she is also not an eyewitness. Then PW6.
Just a minute.
PW6. I know the accused person Zakir Hussain Lashkar. I also know the informant Aklima Begum Lashkar. She is the wife of my maternal uncle, that is deceased. The accused is my cousin and he is the son of the brother of the husband of the informant. On 26/7/2015, in the evening at about 4 p.m., I was at a distance of 1 kilometer from the place of occurrence, where from I saw people started running towards south. Then I also started proceeding towards south by riding my bike. On my arrival in front of the homeopathy pharmacy of Altaf Hussain Chaudhary, I saw my maternal uncle Alimuddin lying dead on the ground by the side of the National Highway in front of the homeopathy pharmacy in injured condition. His head was almost severed from his body and there were other cut marks in his body. The father of the accused, namely Islamuddin Lashkar, was also found in injured condition with cut injuries on his hand and was shifting to hospital. The father of the accused is also my maternal uncle. Many people gathered at the place of occurrence. On being asked, my cousin Ruhul Alam Lashkar, who is also the cousin of the accused, reported me that accused Zakir Hussain Lashkar committed the incident by means of dao. I saw the dao in the police station. Material exhibit 1 is the said dao by which the incident occurred. From the place of occurrence, police seized one religious cap having bloodstain, one pair of sandal, white color Punjabi, a lungi green in color, and a white color cloth screen with Red Cross mark having bloodstain in my presence. I put my signature on the scissor list. Exhibit 4 is the said scissor list and Exhibit 4.1 is my signature. The dead body was taken by police and on the next day, after post-mortem examination, the dead body was handed over to us and we did last rites. Police recorded my statement. Police also seized a motorcycle belonging to the accused from the place of occurrence in my presence. Exhibit 5 is the said scissor list and Exhibit 5.1 is my signature. I was in the place of occurrence for around 45 minutes at the relevant time. In my presence, police arrived on the relevant day at the relevant time. Police seized the motorcycle of the accused and carried to the police station. I cannot say the registration number of the motorcycle. I did not see who brought the motorcycle in the place of occurrence. It is not a fact that no such motorcycle was seized from the place of occurrence on that very relevant day. It is not a fact that I put my signature on the blank paper in collusion with police. I accompanied the dead body to Lala PHC and then to the Lala police station. Thereafter, the dead body was shifted to civil hospital Hailakandi for postmortem examination. And keeping the dead body therein, I went to my house. For the next day, I again came to the civil hospital Hailakandi, and after postmortem examination on the dead body, the same was handed over to us, and we took the dead body. After doing the last rite, police asked me about the incident at the place of occurrence in front of the homeopathy shop. On the date of the incident, police did not seize the wearing apparel, etc. When police asked me about the incident at the place of occurrence, there were 20-25 people present there, some of whom are Altaf Hussain Chowdhury, Ruhul Lashkar, Tuku, handicapped person, and others. It is not a fact that I did not state before the police that I saw Islamuddin Lashkar was shifting to the hospital in injured condition. It is not a fact that I did not state before the police that cousin Ruhul Lashkar reported me that the accused had caused the incident by means of dao, and I have stated the same falsely. It is not a fact that I did not state before police. I saw the dao in the police station. Police told me that the said dao was used in the crime. Police did not state where from the dao was seized. On being heard about an incident, I rushed to the place of occurrence on the relevant day. At night, I saw the accused person in police station. Before 1 week of occurrence, I met the accused. The accused stays near my house in his new house, which is around half mile far from his old house. His new house is 1 kilometer far from the place of occurrence. My house is around 500 meters far from the place of occurrence towards east. After the incident, I visited the house of the informant Aklima. I do not know whether there was any land dispute amongst the accused and my maternal uncle. It is not a fact that on being influenced by the informant, I have deposed falsely. Since I did not see the incident, I cannot say whether the accused Zakir committed the incident or not.
1 minute. He mentioned about his cousin Ruhul Lashkar, Ruhul Alam Lashkar. This did Ruhul Alam Lashkar depose as a witness during the trial?
But there is no such Ruhul Alam. I think it is PW2, maybe. Or may
That's
not
what
be.
I was thinking.
But name is somewhat different.
Ruhul
so,
Alam Lashkar is very, then here though it is Rubul Hussain.
he is Ruhul. But this
Cousin.
thing happened in the rural areas, Lordship. Somehow they called someone. Maybe or may not be. He may be PW2
May
or
not be also.
not.
We have to see inside.
Next one is PW7. I know the accused Zakir Hussain, who is my cousin. That is the son of my maternal uncle. I know the informant Aklima Begum Lotko, who is the wife of the deceased. On 26/7/2015 at about 5 p.m. in an evening, I was in the house of the informant, and at that time, police along with many people came and took me to the house of Altaf Hussain, the brother of accused, and seized a dhow measuring approximately 2 cubits in length, having bloodstain. Subsequently, I came to know from the informant and other people that accused assaulted his uncle, Alim Uddin, and father Islamuddin by means of the dhow. Alimuddin died due to the injuries sustained. Police took my signature in the seizure list by which dhow was seized. Exhibit 3(2) is my signature and Exhibit 3 is seizure list by defense. The informant Aklima and Ruhul also went with us to the house of the Altaf Hussain. Since many people gathered in the house of Altaf Hussain at the relevant time, I cannot say their name before the incident. I never visited the house of Altaf Hussain. My house is at Uttar Jushnabad, Part 2, which is around 6-7 kilometers far from the house of the informant. I was reported that accused Zakir assaulted his uncle and father by means of dhow. Aklima is not my own aunt. I used to visit the house of Aklima. It is not a fact that accused person and the informant are not my relative. Ruhul is my childhood friend. I have not seen the dhow in the court. It is not a fact that I did not state before the police and that the police seized the dhow having bloodstain, and I have deposed the same falsely today. I do not know if the police wrote in the seizure list that the dhow which was seized was stained with a substance like what. It is not a fact that I have deposed falsely that dhow was seized from the house of Altaf Hussain. It is not a fact that I put my signature on the seizure list in collusion with the police in the police station. The contents of the seizure list were not read over to me. It is not a fact that I did not state before police that at the relevant time I was in the house of the informant Aklima. PW8. I know the accused person Zakir Hussain, whose house is around 4 kilometers far from my house. He is the nephew of the deceased Alimuddin. About 2 years back in an evening before dusk, I heard that my nephew Alimuddin was killed by his nephew, but I cannot say the name of the assailant. I also heard that the incident occurred in front of a homeopathy pharmacy. After hearing about the incident, I came there but did not find anything as the injured was shifted to the hospital. I saw blood on the place of occurrence. On the next day, I came to Hailakandi to take the dead body of my nephew Alimuddin from hospital, and then police seized one Genji, one Lungi, one Punjabi. All of them were having blood stains, which were seized by police from the dead body. Exhibit 2 is the seizure list and 2-3 is my signature. Cross declined lodge. PW9. On 26/9/2015, I wrote the Azahar as per version of the Aklima Begum Lodgkor, wife of late Alimuddin Lodgkor of Joy Krishnapur under Lala PS, and the contents of the same were read over to her, and accordingly she put her thumb impression endorsed by me. Exhibit is the Azahar, and Exhibit 1-1 is my signature. 2 is my signature. Exhibit 1-2 is also my signature, whereby I endorse the thumb impression of informant. I do not know anything about the incident personally. It is not a fact that the hazar was not written by me on being requested by one Aklima Begum. Rather, I wrote it on being instructed by others.
He is the
He is the
scribe.
scribe, Lordship. Lordship, PW 10. He claims to be an eyewitness, Lordship. I know the accused Zakir Hussain on 26/7/2015 at about 5:30 p.m. while I was sitting in the veranda of my homeopathy shop at Abdullahpur Part 1, situated by the side of the National Highway. I saw Alimuddin and Islamuddin, two brothers, were coming from southern direction towards my shop. When they came in front of my shop, the accused Zakir Hussain came from northern direction by riding a motorcycle and stopped near them and took out a dao of about 1 cubit length from his bike and attempted to assault his father Islamuddin. But his uncle Alimuddin came in the middle and by raising hand tried to resist the accused. Then accused Zakir inflicted 3 number of dao blow at the heads of his uncle Alimuddin. I, being alone, was helpless and started raising hue and cry. Then his father entered into my homeopathy shop. The accused also entered inside my shop. There was a nun present inside my shop at the relevant time, except the accused and his father. As I was outside my shop, I did not see the accused assaulting his father, but since there was a nun present, from the blood causing injuries of his father, my strong belief is that it is the accused person who had assaulted his father with the said dao. When the accused came out from my shop after assaulting his father, his uncle was lying on the ground, keeping his face upward, almost dead. Then the accused again inflicted the blow at his neck. His uncle Alimuddin died on the spot. By that time, many people gathered there and shifted Islamuddin, the father of the accused, to the hospital. Police took the dead body of Alimuddin. Police seized a cloth screen and one white religious cap having blood stained from my shop in my presence from the place of occurrence. Police also seized one pair of black color nylon sandal in my presence from the place of occurrence. All the seizures mentioned above have been made by Exhibit 4, seizure list, and Exhibit 4(2) is my signature. Police took me to the court and my statement was recorded by magistrate. Exhibit is the said statement under section 164 CRPC, and Exhibit 5(1) and 5(2) are my signature. Police also recorded my statement. Cross. There was a tea stall owned by Jamil near my shop, but at the relevant time, the shop was not in existence. It is not a fact that there were other shops near the stall of Jamil. To the adjacent north of my shop, there is a shop of Aziruddin Baruya, but it was now closed. A bit far from my shop, there is a grocery shop of Onimesh Shuklabotto, and presently it is in existence. It is not a fact that I have stated falsely that the shops of Jamil and Aziruddin Borboya were not in existence at the relevant time. I did not see the actual incident of assault on Islamuddin, the father of the accused.
Okay. You stated the same in chief also.
No. Of the accused. The entire incident occurred within a span of about 2-3 minutes. After I raised hue and cry, the nearby people gathered, among whom Badrul Islam, Hajari, Giyasuddin Lashkar, Jahiruddin Hajari, and others I could identify. Within 1 or 2 minutes after the incident, the people gathered before the people being gathered, the accused left the place with his motorcycle. So, Lordship, his evidence belied the statement of PW7, who stated that his bike was seized from the place of occurrence.
7,
Lordship,
bike.
Lordship.
Let's see. So where he said about bike?
Lordship. It is, may I continue, Lordship?
Where did he state about bike?
Lordship, it is,
He said thou was seized. Thou was seized. He's a scissor witness, PW7, at page 25.
Lordship, it is PW6. Sorry, page 23. Police also seized a motorcycle belongs to the accused from the place of occurrence, page 23, just before starting of the cross, Lordship.
Hmm.
It is not a fact that I have deposed falsely that at the relevant time, that is at about 5:30 p.m., while I was sitting in the veranda of my homeopathy shop situated at Abdullahpur, Part 1, by the side of the National Highway, I saw Alimuddin and Islamuddin. The two brothers were coming from southern direction towards my shop. When they came in front of my shop, the accused Zakir Hussain came from northern direction by riding a motorcycle and stopped near them and took out a dao of about 1 cubit length from his motorcycle and attempted to assault his father, Islamuddin, but his uncle, Alimuddin, came in the middle and by raising hand tried to resist the accused. Then the accused Zakir inflicted 3 numbers of dao blow at the head of his uncle, Alimuddin, and I, being alone, was helpless and started raising hue and cry. Then the father of the accused entered into the homeopathy shop, and then accused also entered into my shop. And at that time, there was none in the shop except my father and the accused. And as such, it is my strong belief that it is the accused person who assaulted his father with dao. When the accused came out from the shop assaulting his father, his uncle was lying on the ground, keeping his face upward, almost dead, and then accused again inflicted dao blow on his leg. The deceased Alimuddin and his brother Islamuddin and their all the family members are residing in the same village where I reside. But the accused, who is the son of Islamuddin, had left the village about 4 or 5 years back of the incident. I have no relation as well as enmity with the accused and his family member, including the deceased. It is not a fact that I have a close relation with the son of Alimuddin, and that is why I deposed falsely. It is not a fact that the statement which I made before magistrate was made by me on being influenced by the sons of the Alimuddin. It is not a fact that accused is not involved in any way in the alleged incident of murder. I have a government registration to run the homeopathy pharmacy, but I have not submitted the same to the police. My residence is around 1 kilometer far from my pharmacy, and I come to my shop through a national highway which proceed in north-south direction. If the complainant had to go Lala, he must come through the front of my shop. It is not a fact that to the adjacent of the place of occurrence, there is a bus stop. On the day of occurrence, I did not visit the police station and hospital. On the day of occurrence, I did not meet the police. It is not a fact that I have deposed falsely on being influenced by the complainant side. PW 11. I know the accused person. I also know the informant. The incident occurred about 2 years back in front of pharmacy of one Alta Hussain. My house is at a distance of about 45 meters from the place of occurrence. On the date of occurrence at about 4:30 p.m., while I was in my house, I heard hue and cry from the place of occurrence, but as I was busy otherwise, I could not go there. After half an hour, I went there and found Alimuddin lying dead with cutthroat injury on the PWD road. I also found Islamuddin in injured condition inside the pharmacy. Myself, along with son of Islamuddin and other shifted Islamuddin to the hospital at Lala and thereafter to Silchar. I came to know from people that the accused killed him, Alimuddin, but I did not see the incident. Alta Hussain is the son of Islamuddin, but said Alta Hussain is not the owner of the pharmacy. On my arrival, I found the sons and daughter of Alimuddin and also some stranger present there. Aklima and her daughter were also there. There are other grocery shops by the side of the said pharmacy. These shops remain open till 8 and 8:30 p.m. It is not a fact that I have stated falsely that I came to know from village people that accused killed Alimuddin. So he is also not an eyewitness. And from his evidence, it is clear that there are more other shops near the pharmacy. And that is easily open up to 8:30. Next, your lordship kindly have a look at evidence of PW 12. I know the accused. He is my neighbor. I know the informant. The incident occurred about 2.5 years back at about 5 p.m. in front of the pharmacy of Alta Hussain. At that time, I was catching fish at the place situated at a distance of around 700 meters away from the place of occurrence. At that time, on hearing hue and cry, I noticed many people running towards the place of occurrence. I also came running and found Alimuddin lying dead on the road in front of the pharmacy of Alta Hussain with cutthroat injury, and the father of the accused, namely Islamuddin, was already shifted to the hospital in injured condition. Gathered people were whispering that accused committed the incident. Thereafter, police came. We lifted the dead body in an ambulance. There were many people found in the place of occurrence, including nearby shopkeepers. It is not a fact that I have stated falsely that gathered people were whispering that the accused Zakir committed the incident. I did not find the owner of the pharmacy, namely Alta Hussain. His statement is somewhat something contradictory, lordship. He did not find the PW 10 at the place of occurrence. But other shops, I have stated falsely that the gathered people, lordship, There are many people found in the place of occurrence, including the nearby shopkeepers. But I did not find the owner of the pharmacy, namely Altaf Hussain. PW Lordship 13. Is the medical officer. My name is Sat and Sat. On 26/7/2015, I was attached to Civil Hospital Hailakandi as senior medical health officer, and on that day at about 1 p.m., I held post-mortem examination along with Dr. Shubhendu Chakraborty on the dead body of Alimuddin Lashkar, aged about 66 years, of village Joy Krishnapur under Lala PS, on police requisition in connection with Lala PS GDNT number 625 dated 26/7/2015. And during examination, we found one sharp cut injury over left side of the throat of size 7 cm into 10 cm into 4 cm. One sharp cut injury over left eyeball continuing to face of size 10 cm into 2 cm into 4. One sharp cut injury over retail region of the skull, left of size 5 cm into 2 cm into 2 cm. The death of the deceased is due to irreversible neurogenic shock with hemorrhagic shock as a result of sharp cut injury by forceful sharp object. In our opinion, the cause of death is ante-mortem in nature, caused by grievous sharp cut injury, which leads to irreversible hemorrhagic and neurogenic shock by forceful sharp object and death. Exhibit 8 is the post-mortem report. Exhibit 8.1 is my signature. 8.2 is the signature of Dr. Chakraborty, which I know. Exhibit 8.3 is the signature of the Joint Director of Health Services, Hailakandi, which I know. Defense, I found all the injuries in the left side of the deceased. The post-mortem was done from 1 p.m. to 3 p.m. PW 14. On 13/1/2016, I was posted at SMCH Silchar as Registrar, Department of Orthopedic. I, being the Registrar of the concerned department, prepared the medico-legal report in respect of one Islamuddin Lashkar from the medico-legal register maintained in our office. As per record, it is revealed that on 26/7/2015, Islamuddin Lashkar, care of Altaf Hussain, male aged about 80 years of Joy Krishnapur under Lala PS Hailakandi, was taken to SMCH Silchar for treatment of his injuries in connection with Lala PS case number 367/2015. Accordingly, he was examined there at SMCH Silchar. I, being the registrar, can say with certainty that I do not have any direction from the concerned departmental head or authority to write the name of doctor who examined the injured, and that is why I cannot say the name of the doctor who examined the injured Islamuddin Lashkar. On 26/7/2015, the injured Islamuddin Lashkar was examined at SMC. The time of his examination is also not discernible from the record, and that is why I cannot say the time when he was examined. From the report, it is appeared that the patient came with a alleged history of physical assault on 26/7/2015 at 4 p.m. at Abdullahpur. On examination, the findings were near total amputation at his right hand at the level of wrist, and the same are as follows. Incised wound of size 5 into 2 into 2 cm cube over right forearm with abnormal mobility of right forearm bones. Incised wound of size 7 into 2 into 2 cm cube over dorsal spine. Inside wound of size 7 to 3 into 1 cm cube over right arm with exposed bone. X-ray is done. X-ray film was not available at the time of the preparing the report. Diagnosis: total amputation of right hand at the wrist joint with a type of 3B compound fracture, both bone, right forearm. Nature of injuries were grievous in nature, caused by sharp object and same were fresh. Exhibit 9 is the medical legal report issued by me. 9.1 is my signature. 9.2 is the signature of A.K. Dolagupu, Professor cum HOD, Orthopedic Department, SNCH, Silchar. I did not examine the patient. There is no mention in the report as to the person who identified the injured. With such types of injury, the patient may die subject to his physical condition. The patient may explain as to how he sustained the injury at the time when he appears before the doctor with such types of injuries. In the medical legal register, the name of doctors who examined the injured or patient in the emergency, their signature are available. Without perusal of medical legal register, I cannot say the name of the doctor who examined the injured of this case. PW 15, Lordship. I know the informant Aklima Begum. She is my neighbor. I also know the accused person and he is also my neighbor. About 2 years back, one day at about 2:30 p.m., while I was returning home from market, on the way near Shokala Digirpar, I found gathering of people and saw one Alimuddin Lashkar was found lying on the ground with cut injuries on his neck and other parts of the body. Thereafter, police came and along with me went to the house of the brother of the accused, namely Altaf Hussain, alias Altaf Hussain, where we found one of the houses under lock and key. Then, under instruction of police, people had broken the door of the house and police asked me to enter inside. Accordingly, I entered inside along with police but did not find any person there. Then we noticed one dog lying beneath a bed with the police seized in my presence. I put my signature on the seizure list by exhibit 3 and 3.3 is my signature. Police also seized one religious tape having blood stain, one white color curtain, one pair of nylon sandal from the said house of Altaf Hussain by exhibit 4 and 4.3 is my signature. The dhow was very much clean. Today I have not seen the seized dhow and other articles in the court. When I, along with police, entered inside the house, there were many people gathered and some of them entered into the room. The accused reside at Lalachara. It is not a fact that I did not state before the police that on the relevant date about 2:30 p.m. while I was returning home from market on the way near Shokala, Digirpat, I found gathering of people and saw one Alimuddin Lashkar was found lying on the ground with cut injuries on his neck and other parts of the body. Thereafter, police came and along with me went to the house of the brother of the accused, namely Altaf Hussain. Altaf Hussain, where we found one of the house under lock and key. Then under instruction of police, people had broken the door of the house and police asked me to enter inside. Accordingly, I entered inside along with police, but did not find any person there. And then we noticed one dhow lying beneath a bed. It is not a fact that I have proposed.
Okay, rise for 5 minutes.
That's PW 16, page 43.
This was the house of Altaf Hussain, no? Where Dow was found. This PW 15.
It is Altaf Hussain PW 4.
Okay.
15 is a neighbor otherwise.
Lodge. On 27/7/2015, I was posted at Hailakandi as judicial magistrate, first class, and on that date at about 12 p.m., Learned CGM Hailakandi forwarded the accused Zakir Hussain Lashkar, son of Islamuddin Lashkar of Jayakrishnapur under Lala PS, Hailakandi, for recording his confessional statement. In my chamber, I interacted to the accused in order to ascertain whether he was ready to confess voluntarily or under any fear or coercion. At that time, in my chamber, there was a third person present. The door of my chamber was closed. I asked the accused who brought him before me. He replied that he was taken by police. Then I ascertained that there was no police person present in my chamber and even in the doorstep. After the interaction, the accused very freely and voluntarily told me that he wants to confess his guilt, and after being satisfied about the voluntariness, I decided to record his confession. I also made him aware repeatedly that if he confesses his guilt, it may be used in evidence against him. I have given 5 hours reflection time, and since the offense alleged to have been committed is under section 302 IPC, I gave him to the custody of PSI Hailakandi, prosecution sub-inspector. In the evening at about 5 p.m., I required the presence of accused in my chamber, and accordingly, the accused was produced before me from PSI office. Again, I asked him whether he was willingly deposed voluntarily and made him aware about the consequences of the confession, stating that it may be used in evidence against him. I put many questions to him to ascertain the voluntariness. Thereafter, on being satisfied of his voluntariness, I recorded his statement on oath. He has confessed that there was some land dispute between he and his father and uncle, and on the relevant day, when he met his father and uncle on the way, he asked them to settle up the dispute, and then his uncle Alimuddin Lashkar took out a lathi in order to assault him. Then he ran near to his motorbike and took out a dao and started inflicting assault on his uncle Alimuddin Lashkar, to which his uncle fell down, and then his father Islamuddin Lashkar tried to assault him with lathi, to which he hit his father with dao. Exhibit 10 is the said confessional statement of the accused in 5 pages. Exhibit 10(1) is signature. Exhibit 10(2) and 10(7) are my signature, are the signature of the accused. After the statement being recorded, I read over the contents of it to the accused, to which he admitted the same to be correct and true. Cross. It is not a fact that I did not make any attempt to inquire the mental condition of the accused, whether he was a fit state of health and mind to say truth, and whether he was making his statement voluntarily or not. It is not a fact that contents of the statement were not referred to the accused. The word oath is not mentioned in the statement, but I recorded his statement on oath. It is not a fact that I did not record his statement on oath. It is not a fact that accused was made to confess by police under compelling circumstances.
Yes.
But this confession was rejected by the Learned Trial Court.
Why?
Lordship, on the ground that there is a illegality while recording, as he was under the influence of the police, so it is not voluntary. That's why Learned Trial Court.
He was in police custody.
Yes.
No, that
Before-
is why he was already
Up-
on police custody, so the magistrate. He
It
was sent to PSI
a PSI
for some time.
for 5 hours,
Mm.
and then his statement was recorded. That's why it was rejected. PW 17, Lordship.
But he was in JC or police custody? I think he was in, because if he was in police custody, he was required to be sent to JC before recording the police court session, judicial custody
Noted.
to the jail. So anyway,
On 13, PW 17, on 13th November, I was working as scientific officer, Virology Division, FSL Assam. On 29/7/2015, I have received a letter from Additional SP, Headquarter Hailakandi by memo number such and such for examination, which was received on 31/7/2015 in connection with Lala PS case number such and such under section such and such. The above articles were received by me in a seized parcel packet, which was left with cloth covered with a wooden box, and inside the box there were 6 items wrapped with a cloth, which was sealed and signed by the SP Hailakandi. The above 6 items were labeled as 3354 A to 3354 F. The description of the articles: one white color half kg packet in polythene bag contains stain of suspected blood marked as A. One multicolored lungi stain of suspected blood marked as A. One white colored Punjabi shirt containing stain of suspected blood marked as A. One ash colored cloth stain of suspected blood marked as B, MR number 59, 2015. One white colored cap contains stain of suspected blood marked as B, MR number 59 of 2015. One wooden handle dao contains stain of suspected blood. Total length with handle is 83 cm approximately. The blade of the dao is moderately rusted. The handle of the dao is wrapped with a jute rope marked as C, MR number 58, 2015. After result of my examination, I have given my opinion, wherein I have stated that exhibit 0 number such and such gave a positive test for human blood of group A. Exhibit P1 to PW 17 is my report.
only saying human blood is not sufficient. Only saying human blood is not sufficient.
No.
Human blood can be there, but human blood of whom?
No. Is my signature. After my report, the same was forwarded by the Director cum Chemical Examiner, Government of Assam, Director of Forensic Science Assam, Kahilpara, file number such and such, is the signature of the then Director, namely Sri Bhupen Bora, which I know. Cross. In my report, I have not mentioned on which specific date I have examined the material. The articles are examined by me on different dates, which are available in my official record. In my report, I have only mentioned regarding the blood group found in item number 1 to 5, item number 6, but I cannot say if the blood stain found in the article are of one specific person. Only DNA examination can determine as to whether the blood found in the above 6 item belongs to one person. It is not a fact that my report regarding the human blood stain in item number 6 is not correct. PW 18 is the IO lordship. This evidence is very important. On 26/7/2015, I was posted at Lala PS, and on that day at about 5:10 p.m., the then OC of the PS received an information, and accordingly, Lala PS GGNT number 625 dated 26/7/2015 was registered. I was asked to take steps, and accordingly, I started my investigation. During investigation, I visited the place of occurrence, drew up rough sketch map thereof. I found victim Ali Muddin Lashkar and sent him to hospital for medical treatment, but later on, the said person expired. The inquest on the dead body was done by me. Thereafter, the dead body was sent for PM examination, and accordingly, I collected the PM report. I examined the witnesses and also got the statement of few witnesses, namely Alta Hussain Chowdhury, Sainara Begum, recorded under section 164 CRPC. I also seized one dao, a nylon rope, one blood-stained cap, white color curtain, and also one motorcycle bearing such and such, and accordingly those articles were seized. The seized six number of articles, that is one Ganji, Lungi, Punjabi, etc. All the articles were sustained with suspected human blood, were sent to FSL for chemical examination, and accordingly the report was collected. One victim, namely Islamuddin Lashkar, was sent for medical examination, and accordingly his medical report was collected by me. I also collected PM report and statement of the witnesses under section 164 CRPC. I arrested the accused, and thereafter I sent the accused for recording his confessional statement before the magistrate. And accordingly, the confessional statement was recorded, and I collected the seized. Thereafter, the completion of investigation, I submitted the charge sheet against the accused person. Exhibit 1 is the inquest report. Exhibit 1, 2 is my signature. Exhibit 2, 3, 4, 5 are seizure list in respect of seizure of blood-stained articles, wherein Exhibit 2, 4, 3, 4, 4, 4 and 5, 2 are my signature. Exhibit 513, PW18 is the sketch map, and Exhibit 513 1 is my signature. Exhibit P14 and is the charge sheet, wherein Exhibit P14 is my signature. I examined witness 1 Altaf Hussain Lashkar, and in his evidence he stated that his brother Zakir Hussain, in order to kill his father, caused serious injuries on his body by means of dao, and also killed his uncle Alimuddin. That is Altaf Hussain Lashkar, PW4. But he is also not an eyewitness. In the JDNT, there is no specific name of the accused. There is no mention as to who gave the information to the OC for recording JDNT. Exhibit A is the relevant JDNT, which was recorded by the then OC of the PS. The FIR was received by the OC on 26/7/2015 at 11:30 p.m. In the seizure list, there is no mention about the recovery of the dao from possession of the accused. It is not a fact that I have falsely written in the seizure list that articles were produced and handed over by witness Shayanara Begum Lashkar. It is not a fact that said witness did not voluntarily put her signature in the seizure list. I cannot exactly say whether the stain on the dao was actually of blood or not. In the seizure list, I have not mentioned as to under what reference I went to the
Mr.
house
Mazumdar, the dao was recovered from where?
It is from the house of PW4,
Altaf Hussain.
Altaf Hussain,
beneath the bed.
Lordship. From the
And-
house of,
And Altaf Hussain is related to the accused,
he is the brother,
own brother.
yes, elder brother. Accused is the younger brother of PW4.
There is also a 164 statement, right, of Altaf Hussain.
Altaf Hussain, it is PW10.
Oh, okay.
Two persons,
Sorry.
164 statement was recorded, one Altaf Hussain and other PW, one Sainara Begum. Their statement was recorded. I took the dao to the police station and kept it in the police station, Malkana. It is not mentioned in the case diary that the said dao was kept in the safe custody of PS Malkana. The seized dao was sent to FSL for examination by me on 29/7/2015. It is not a fact that I have deposed falsely that I seized the dao from the possession of Shaira Begum and brought it to the police station and kept the same in PS Malkana. But one of the witnesses stated that it is from the house of the Altaf Hussain. The seized dao was not sent to fingerprint expert for verification. I do not have any concrete proof to show that the dao belongs to the accused. Very important, Lordship. I do not have any concrete proof to show that the dao belongs to the accused and he used the same for committing the offense. I did not verify whether the seized motorcycle belongs to the accused or not. It is not a fact that I have deposed falsely that motorcycle was seized from in front of the house of Jahangir It is not a fact that I deposed falsely that the motorcycle was seized from in front of the house of Jahangir and said Jahangir put his signature as a witness in the seizure list. It is not a fact that accused did not use the motorcycle as stated by the Jahangir. It is not a fact that Exhibit 5 seizure list was prepared collusively. It is not a fact that PW1 Aklima Begum did not state in the Azahar as well as in her statement before me that when she reached the place of occurrence, she saw accused Zakir Hussain leaving the place of occurrence, being argued down in a motorcycle. It is not a fact that said witness did not state before me that she came to know about the incident from his son, Ruhul, and when she came to the place of occurrence, she saw cut injuries on the neck, face, and head of the body of her husband. It is not a fact that PW2 Ruhul Hussain did not state before me that he was on the national highway at a distance of 4 knots away from the place of occurrence. It is not a fact that said witness did not state before me that he found Zakir Hussain coming from Lalachora by riding a bike and he stopped near the pharmacy. It is not a fact that PW2 did not state before me that thereafter the accused came out of the pharmacy and found his father alive. He kept more dowbrow on the neck of his father. And as a result, his father died in the spot instantly. It is not a fact that aforesaid witness did not state before me that immediately after the incident, his brother and sister came to the place of occurrence and he told the entire incident to his mother. In my case diary, I have not mentioned the distance between the place of occurrence and the house of PW2, Rubul Hussain. But so far I remember the distance would be more than half kilometer. From the place of occurrence, house of the victim is around half kilometer. I visited the place of occurrence for the first time on the date of occurrence itself, and thereafter I visited the place of occurrence on the following days. I visited the place of occurrence at 5:30 p.m. after recording GDNT. Before my arrival at the place of occurrence, no police personnel visited the place of occurrence. Till 12 p.m. on the same day, I was at the place of occurrence, and during that period, I recorded the statement of the seizure witnesses only. It is not a fact that PW3, Jahangir in his evidence did not state before me that Altaf Hussain came to his house immediately and told him that his father Islamuddin and uncle Alimuddin were murdered, and then he boarded the auto rickshaw of Altaf Hussain and went to the place of occurrence. On the same day, I recorded the statement of the witnesses Jahangir and also took his signature in the seizure list. It is not a fact that witness number 4, Altaf Hussain Lashkar, was not examined by me. It is not a fact that PW4 did not state before me that his brother Zakir Hussain, in order to kill his father, caused serious injuries on the body by means of daw and also killed his uncle Alimuddin. It is not a fact that PW6 Nasiruddin Borguya did not state before me that he saw Islamuddin Lashkar was shifted to the hospital in injured condition. His cousin Ruhul Lashkar reported him, PW6, that the accused had caused the injuries by means of daw. That he saw the daw at the police station and police told him that the said daw was used in the commission of the offense. It is not a fact that PW7 Mujahidul Islam Borbuya and did not state before me that police seized the bloodstained daw and he was in the house of Aklima at the relevant time. It is not a fact that PW15 Yahya Madarbuya did not state before me that on the relevant date about 2:30 p.m. while he was returning home from the market and on the way at near Shokala Digir Park, he found gathering of people and saw one Alimuddin Lashkar was lying down on the ground with cut injuries on the neck and other parts of his body. Thereafter, police came and along with police, he went to the house of the brother of accused Altaf Hussain, where they found one houses was under lock and key from their lordship, and under instruction of police, People broke open the door of the house and police asked him to enter inside the room. Accordingly, he entered along with police inside the room, but did not find anyone there. Then they noticed that one dog was lying beneath a bed. It is not a fact that exhibit P13, the sketch map was not properly drawn up by visiting the place of occurrence. In the sketch map, I did not mention about the marks of violence, existence of blood stain, etc. at the place of occurrence. I have prepared the sketch map, exhibit 13, at the place of occurrence. Along with sketch map, I have also recorded other entries in the case diary as to the steps taken by me after preparation of the sketch map. There is a no witnesses sketch map to show that I have prepared the same at the place of occurrence. In presence of witnesses, it is not a fact that beside the pharmacy, there are other shops and houses near the place of occurrence. It is not a fact that there was no material to submit the charge sheet against the accused person. Now, I take your lordship to JTNT. Based on which investigation started, lordship, JDNT, lordship, kindly have a look at page 189 of the paper. Now, someone from Joykrishnapur, Shokalatpara, informed over phone that a person has killed his uncle by hacking him with dao at the place of occurrence and caused a grievous injury to his father. Accordingly, an entry is made, and I, SI M Islam, along with SI HH Lashkar, CI Lala, and staff move out to Shokalarpar, that is the place of occurrence. So in the JDNT, his name is not there. There is a no mentioning of the any eyewitnesses. And out of 18 witnesses, not a single witness is whispered about the fact that PW2 and 10 witnessed the occurrence. Not a single witness is anywhere stated that 2 and 10 witnessed the occurrence. In the Azahar also, his name was not mentioned, that he has, there are two, his son witnessed the occurrence. And
Mr. Mazumdar, what is the purpose of a GD entry? Is it required to be in so elaborate manner?
No, not
Even an Ajahar is also not required to be in
but lordship, eyewitness as well as name of the accused is required. I will rely
Is
on
it
this.
required? Suppose even the concept of zero Ajahar is there.
No, lordship, that is in case to case, that is very.
No, but here, will it be fatal to your case?
Yes.
Why?
There is a
Not be
great
fatal.
chances, lordship, concocted story, lordship. I'll show lordship judgment.
That by itself per se will not make the prosecution case fatal. Not mentioning in details the name.
But
It is only to put the criminal, the machinery into motion.
But that is true. But basic that at least should be
Suppose
mentioned.
what is required to be done in an affair?
Lordship,
Is it inconsistent?
No,
You can make out a case if the informant in her statement before the as a witness, she says something which is conflict with the version in the affair, in the Ajahar. Matter would be different. But not mentioning in details in the Ajahar, will it make?
Lordship, name of
Then-
eyewitnesses is required to mention.
Why is it required?
Lordship,
At that moment,
otherwise
when was the affair lodged? Have you noticed?
at
Affair was lodged
11:30.
on the same date at 5 p.m.
And no, Azahar lot is 11:30 p.m.
Incident was at 5 p.m. Azahar lodged on the same date.
Lordship,
At the heat, and who had lost the affair? The wife.
wife.
At the heat of the moment, it was by a scribe.
But Lordship,
That itself will not be a point.
Lordship,
You concentrate on other grounds.
Lordship, in support of that, Lordship, I'm relying on judgment. I'll read Lordship, and later on I'll supply a copy of the Lordship citation.
You concentrate on other points. We think that you may have some other points.
Lordship.
Encyclopedia, it's not an encyclopedia, it's been reiterated case after case.
Lordship, may I read one paragraph? Ramkumar Pandey, state of, I'll supply the copy, Lordship, later on, but just I am reading 1975, 3 SCC 815. Lordship, may I read?
815.
Lordship. No doubt, an FIR is a previous statement which can strictly speaking be only used to corroborate or contradict the maker of it. But in this case, it had been made by the father of the murdered boy, to whom all the important facts of the occurrence, so far as they were known up to 9:15 p.m. on March 23, 1970, were bound to have been communicated. If his daughter has seen the appellant inflicting a blow on Harbinder Singh, the father would certainly have mentioned it in the FIR. We think that omission of such important facts affecting the probabilities of the case are relevant under Section 11 of the Evidence Act in judging the veracity of the prosecution case. Even Joginder Singh, PW8, was not an eyewitness of the occurrence. He merely proves an alleged dying declaration. He stated that Harbinder Singh rushed out of his house by opening its door and held his hand on his chest with a blood flowing down from it. He deposed that when he asked Pappy what had happened, Pappy had stated that Suresh and Pandey had injured him. It is clear from FIR that Joginder Singh had met Uttam Singh before the FIR was made. Uttam Singh did not mention there that any dying declaration indicating that the appellant had also injured Harbinder Singh was made by Harbinder Singh. The omission to mention any injury inflicted on Harbinder Singh by the appellant in the FIR seems very significant in the circumstances of this case. Indeed, according to the version in the FIR, Joginder Singh, who was in the lane, is said to have arrived while Harbinder Singh was being injured. Therefore, if this was correct, the two injuries on Harbinder Singh must also have been inflicted in the lane outside. The wife of Uttam Singh, who claimed to have been an eyewitness of the whole occurrence, was also not mentioned in the FIR. Suresh had, according to her, stabbed Harbinder Singh on the right side of the chest at the door of the kitchen, and thereafter Pandey was said to have attacked him. Again, we find that Taranjit Kaur, PW2, and Amarjit Kaur, PW6, daughter of Uttam Singh, have figured as eyewitnesses of the whole occurrence, including the stabbing of Harbinder Singh by the appellant. As already indicated, they are not mentioned in the FIR. So in this case, they were not mentioned in the FIR as eyewitnesses of the murder. This is also very significant in the present case. They have been mentioned only as witnesses of wrapping a chador on the wound of Harbinder Singh, who was then said to be lying in the lane after the occurrence. This is one. Another, Lordship. Just I'm reading, Lordship. I will supply all this copy after later on, Lordship. It is very recent judgment, Lordship. Judgment criminal appeal number 715 2018. 2018 criminal appeal number. But judgment very recent, Lordship. I'm reading, Lordship.
Judgment dated?
Judgment date is also. It is
The Supreme Court.
Lordship, Supreme Court. Tested against
Name of the parties?
name of the party Najim and other
And
appellant versus state of Uttarakhand respondent.
Paragraph?
Paragraph 29 and 30, Lordship.
Yes, what has been laid down?
It is regarding Lordship dying declaration. That was not mentioned. So Honorable Apex Court, that is also taken into consideration. I'm reading Lordship. Tested against this principle in the present case, the evidence on record can in no fathomable circumstances complete the chain of circumstances pointing to the guilt of the accused person. The prosecution case reveals substantial gaps. The first and most glaring circumstances is the omission of the name of Najima Aftab in the
That is a
FIR.
case based on circumstantial evidence.
No, Lordship, but
In that context, the link was said to be incomplete. Here is not a case of circumstantial evidence.
Lordship, I just reading Lordship, will consider Lordship. The Najim and Aftab in the FIR, PW1, the complainant and the father of the deceased expressly named 6 persons with whom he admittedly had long-standing enmity, yet he did not attribute any rule to the present appellant, Nazim and Aftab. This court in Ram Kumar Pandey, which I have already Lordship stated, state of Madhya Pradesh, has emphasized that when important facts are omitted in the Ezahar, such omission are relevant under Section 11 of the Indian Evidence Act 1872 in judging the veracity of the prosecution case.
Relevant, definitely. It is relevant. But how much it affects the prosecution case would be another matter.
In the present case, both PW1 and PW2 were admittedly familiar with Najim Aftab. Despite this, their names were not mentioned in the FIR, nor was any contemporaneous explanation offered for their absence. The High Court acknowledged the omission but brushed it aside as inconsequential. This approach is untenable in a case based solely on circumstantial evidence. Every circumstances must withstand rigorous scrutiny. The failure to name 2 of the 3 appellants in the FIR, despite the complainant's familiarity with them, cast a serious shadow on the subsequent attempt to implicate them. It raises a legitimate inference that their names were introduced at the later stage, thereby suggesting the possibility of false implication. If PW1 and PW2 genuinely believe that Nazim and Aftab were responsible, there is no plausible reason for their omission in the FIR. This significant omission strikes at the roots of the prosecution narrative, undermine its credibility, and constitute a material fact that must weigh heavily in favor of the accused. Another on GD entry, it is our High Court judgment. Thus, it is apparent that information.
Give the citation.
Oh, Lordship. Gauhati High Court, 2016, 5 GLT 69.
Name.
Name of the party Aminur Islam, within bracket MD and others versus State of Assam.
Aminur.
Aminur.
L.
Yeah, R.
R.
Aminur. Criminal appeal number 179 of 2012.
Paragraph.
Paragraph Lordship 64, 65, 66. 63 also.
Yes, what has been laid down?
Thus, it is apparent that information regarding the cognizable offence reported to police on the night of 31st August 2000 itself, and on the basis of such information relating to cognizable offence, police too swung into action, visited the place of occurrence, and recovered the dead body from such place. More importantly, took the dead body to the police station. This clearly shows that Exhibit 2 was not first information. Rather, it is an information which police received during the course of investigation. First FIR being one which was evidently drawn on the basis of a information furnished by PW5 on the night of the incident itself. Here I'm trying to submit Lordship, that is once GD entry was recorded and based on that investigation initiated, subsequent lodging of FIR is hit under section 162 of the Evidence Act.
So there is no requirement on FIR if a GD entry is recorded.
So once if investigation initiated, based on that, subsequent FIR is not necessary. It can be treated as 161. If not, investigation not initiated, that event that can.
So after receiving of a GD entry, the police will sit tight.
No, usually the FIR is required for registering a case, right?
That may be, but
Suppose in practical situation, police gets a message, a GD entry entry is made in the general diary. Then they'll sit tight for the FIR to come. The proposition is not correct, neither factually nor legally.
I'm.
Telephonic information can also be
Anything,
treated
any
as a
information,
FIR.
they not wait for a
First
jar.
information. Then the second one is a 161, as you said.
Since the exhibit 2 was brought into existence during the course of investigation, such a statement is hit by section 162(1) of the CRPC, and as such, in the terms of the aforesaid provision, exhibit 2 becomes an inadmissible document, and as such, same needs to be removed from the list of evidence tendered from the side of prosecution. In this connection, we may profitably peruse the decision of this court in the case of Ganesh Gogoi versus State of Assam, reported in 2000. Then Lordship, para 65. We have already found that prosecution case suffers from several serious infirmities. Such infirmities become more and more severe and harsh in their effect once the exhibit 2 is removed from the list of evidence. Not producing the original FIR before the court has come other adverse implication on the prosecution, that is unnecessary. So next, Lordship. Delay, Lordship. There is a delay also. There is a 6-hour delay in lodging the SIR. There is every possibility to develop a story. Lordship also considered this on that aspect.
Delay of 6 hours.
Lordship. In the fact and circumstance of the present case, it is Lordship, my humble submission that may be taken into consideration. And also, Lordship, now I am coming to the fact of the present case. Lordship, thou was recovered from the house of PW4.
Yes.
There is a and PW4, but whether that contains human blood or not, that was not conclusive.
No, human blood is conclusive,
but,
but whose blood, that is not clear. Forensic department.
Whether it is of the deceased or not, that was not made clear, Lordship. One aspect. Other aspect, Lordship, whether PW 2 and 10 are the eyewitnesses or not. Lordship will consider PW 12 categorically stated that he did not see the PW 10 at the place of occurrence. And no other witnesses also anywhere in their evidence stated that these two persons witnessed the occurrence. Nobody whispered it. In the Azahar, who are the eyewitnesses? That was not stated. And Lordship, PW 4 also stated that injured witness stated to him that one person assaulted him whose face was covered with a cloth. although he was cross-examined by the prosecution, but he was not declared hostile. If defense relied on the evidence of PW4,
There is no recording that he was not declared as hostile, but the
but-
moment he's cross-examined, I think this submission you should not make.
no, substantial.
That is not required.
But
It's a
from
very
his
technical kind of an objection.
and other thing, Lordship, a person committed a crime in the daytime. It can be presumed that even if assuming that he was there, accused was there, but it is very much clear he was with a covered face. From the statement of
Only
PW,
one witness has said he has been
Yeah.
declared hostile. Others have not said.
no, other have not said, but other have not seen also, Lordship.
No, what
Who
about
has-
2 and 10?
But 2 and 3 is very, Lordship, very much suspicious witness. They are not reliable. None of them was present. House of the PW2 almost 500 meters away from the place of occurrence. But he stated that his house is near to the place of occurrence, only 200 meter like that. And he was at a distance of 3-4 knots. Why he witnessed? There is no attempt, there is no evidence as such that he made any attempt to protect the victim from the assault of the accused person. No such attempt. He was a mere silent spectator, just witnessed the occurrence. No attempt was made to save the accused person, Lordship, victim from the clutches of the accused, Lordship. So under such a circumstances, whether he is a reliable witness or not, Lordship will consider. So far as PW10, Lordship, I take your Lordship to once again, Lordship, page of the paperwork, Lordship.
Page?
Page 35. At the down below, Lordship, cross part. There were many people found in the place of occurrence, including nearby shopkeepers. It is not a fact that I have stated falsely that the gathered people were whispering that the accused Zakir committed the incident. I did not find the owner of the pharmacy, namely Rahushan. And from his entire evidence of PW10,
Yes.
he also did not make any attempt to protect the alleged victim, Lordship. So under totality of the circumstances, Lordship, whether PW10 and PW2 is believable. So far as confessional statement, learned trial could discard it. That aspect I am not going. And no cross appeal, there is no challenge. So in the totality, Lordship, whether PW 10 and 2 is a reliable witness to sustain conviction. On the other hand, Lordship, I take your Lordship, para 77 of the impugn judgment. Finding of the learned trial court also purpose. In para 73, Lordship, may look. May I read the para 76, Lordship?
77 you had said.
Before that, Lordship, 76, Lordship. From the evidence of witnesses on record, it appears that there are two eyewitnesses to the occurrence, that is PW2 and PW10. The statement of PW2 and PW10 goes to show that occurrence took place on 26/7/2015 at about 4:30 p.m. PW10 is the owner of the said homeopathy shop, and the incident occurred right in presence of PW10. He described as to how the accused came and stopped near both the victims who were standing in front of his shop. The accused came in a motorcycle and took out a dao and inflicted blows on the deceased outside the pharmacy. Thereafter, the other victim entered into the pharmacy, and the accused also entered into the pharmacy and inflicted dao blows on him. As a result, victim Alimuddin died on the spot. The inquest report and the postmortem report clearly reflect that the deceased Alimuddin received fatal blow of his vital organs, as a result of which he died due to shock and hemorrhage. The other victim, namely Islamuddin, was immediately shifted to Lala Hospital, and thereafter he was taken to SMCH Silchar. The postmortem report and the medical report clearly establishes the fact that the blows were inflicted with sharp weapon. The IO seized blood-stained cloth as well as dao, which was also stained with blood, and same were sent for FSL examination. The expert, after examination of the articles, found that the seized dao was sustained with human blood. The evidence of the two eyewitnesses was also corroborated by the other witnesses who reached at the place of occurrence on hearing hue and cry. And on their arrival, they saw deceased Alimuddin lying dead on the ground, and victim Islamuddin received injuries with sharp weapon. The prosecution side failed to examine said surviving victim, namely Islamuddin Lashkar. The surviving victim could not be examined during trial, as the said victim died while the case was pending for trial. The evidence of IO clearly goes to show that he arrested the accused and thereafter made prayer before the learned CGM for recording confessional statement of the accused. Subsequently, the confessional statement of the accused was recorded under section 164 CRPC by the learned judicial magistrate first class, after being satisfied his willingness and truthfulness of giving such statement. In the instant case, there are two eyewitnesses who came to the place of occurrence, and the evidence of both the eyewitnesses has been found to be direct, cogent, and trustworthy. The law is very clear that the testimony of a solitary witness, if found to be reliable and trustworthy, then conviction can be made on the basis of such evidence. A three-judge bench of the Honorable Apex Court passed in judgment dated such and such in criminal appeal number such and such, and held that the quality and not the quantity of the witness matter, and even the testimony of a single eyewitness is sufficient for the conviction of the accused. In the instant case, the testimony of witness found to be corroborative to one another, and the quality is to top notch directly, pointing the finger to the accused of committing offense. Admittedly, there was some land dispute between the accused and his father regarding the partition of ancestral property. This finding is totally perverse. The entire evidence on record, nowhere any of the witness stated that there is a land dispute between the parties, between the accused and the Lordship appeal.
I think there is.
No, Lordship, only it is PW 16 stated somewhere in the evidence I have found.
There is.
He stated about in the confessional statement. it is
Confessional
there.
statement.
That I remember.
Lordship.
But
but-
other witnesses have to refresh again.
Lordship, other was
You have
not
to see.
stated.
Have to see. It's not there.
Lordship. It is not in respect of others. So this finding, my humble submission, is a perverse finding. Thereby the accused had good reason to commit the above offense.
Motive, that means.
out of anger and frustration. There is nothing on the record to believe that
No,
the
no, you
witness.
come to page 10. There is, page 10. Page 10. Where's the last part? Please see page 10. The paternal properties of my husband was amicably partitioned, but not partitioned formally. Have you got? I can say whether there was any dispute regarding the land between my husband and my injured brother-in-law. There is a mention.
I can say,
I cannot say or
but I think there is some
cannot say
mistake.
whether
But
there was any dispute.
Lordship, our narration kindly have. I can say whether there was any dispute regarding the land between.
Land has come, but
it has, the sentence is more,
Something wrong is there,
I
and
cannot
already
say.
stated that there is amicable partition, though there is no formal partition.
From where was he? And the dhow was seized from the house of PW4. How is the accused connected to PW4?
Brother,
No?
brother.
Own brother. Accused stays in the same house.
His wife has testified, right? Sanara Begum. PW4. Yeah, she said that it was kept in his. Her brother-in-law kept the dhow in their house. Yeah? Something like that. He states that. 164 she states.
Why was the confessional statement? No, it was not taken into consideration by the learned court. Now that you have stated, what is the aspect that?
He was in police custody.
Now, how much time was given for reflection?
6 hours.
Huh?
PI. PI. But he was brought from police custody. He should have been sent to JC.
Three one three. From where was the motorcycle seized?
Yes. Yes.
Now, see, if you see the motorcycle part at page 23. Page 23. 23. Page 23. You have said you're not from the place of occurrence. Let us see the scissor list.
26, the Dow, the silver list, particularly the Dow, indicates on 26 only, same day. Page 153. On bloodstream sharp down.
And 57. House plot, house plot, house plot, house plot. Nothing but paper, house plot. Only this address is really.
Motorcycle was seized on 27/7.
Comfort and interrupting the board. Even go. It's interesting. Page 17 now. Page 17. Down go. PW3. PW3, AP 16 of the envelope. He is one of the witness to the witnesses of the motor vehicle concern. Into AP 17. He does not speak anything. He only speaks about exhibit to Caesar list, which is with regard to those wearing apparels. Wearing apparels. Not about, no, nothing. Hotel exhibit is the box. And if you come to page 159, 159, 150, 158, 157. 157 is the Caesar list as far as the bike is concerned, motorcycle. And description, if you come 157. Description, okay. And next page. Witnesses. Something is not an witness, this is an witness. He is PW3 and Nasiruddin is PW6. Now, he says that it was he's from the better his really says that it was on the path and pathway to Dhangadri. House path. Okay, well, you know, huh? Okay, then tomorrow as the first item, immediately if there are no motions,
After motion.
as a main consideration matter, this will be the first item. Two hearing matters. Orders will not take much time. Orders will be either for the purpose of service or IA for.
After motion.
Yes. Okay. Okay. Hmm? Motion tomorrow.
No. Only
Motions are there.
No. Only order.
No? Admission, motion to not take. Order to someone like IA take it. अभी हिट को पर गलत कर देते हैं Mr. Madhundar, if not tomorrow, then it will be difficult.
Tomorrow is extension of the bench, right? Just till today.
Heard L.R. Madhundar, learned counsel for the appellant, who has concluded his argument. Full stop. However, a prayer for accommodation has been made on behalf of Miss B. Bhuyan, learned APP. Full stop. In view of the above, list for further consideration tomorrow. How's the particular date did you go? We'll sit single bench in 5 minutes.
For the liberty of judge them,
in WPC 5997/2002. In the conspectus of the aforesaid discussion, this court is of the opinion that the impugned decision-making process is based on relevant and genuine considerations, and there is no element of any arbitrariness in the same. Impugned decision-making process also does not appear to be vitiated by any mala fide. In view of the above, writ petition fails, and accordingly, the same is dismissed. Now, before this bench, we are only temporarily sitting. We are a division bench. Mention it before the appropriate bench. Item 1. Yes. Yeah, we remember, yes. No, understood. But if the DB has said so, we'll have to follow the DB. We'll close it. We'll close it. We'll record your submission. Okay. Okay. Heard 3 SC Kyle, learned counsel for the applicant. Also heard 3 A Shandilla, learned counsel for the respondent numbers 1 and 2. Full stop. Para. The instant application Madam, the court is going on. Don't shout in the court. The instant application has been filed, filed under Order 9, Order 10 of the Gauhati High Court Rules 2015, read with Section 114 and Order 47, Rule 1 of the Code of Civil Procedure for review of a judgment and order dated 16/12/2022, passed in a bunch of writ petition, including WPC 4385 of 2022. Full stop. Para. The primary ground of seeking review was that was on the basis of a judgment, an order of the Honorable Supreme Court dated 18/10/2024, passed in review within bracket civil number 359 of 2023 in civil appeal number 5783 of 2022, bracket mein Union of India and another versus Messrs. Ganpati Dealcom Private Limited. Full stop. Para. It, however, transpires that subsequent to the aforesaid decision, the Honorable Supreme Court has passed another order in SLP number 8229 of 2020, 82 now 2024, dated 4/11/2025, by holding that the review would not be maintainable. Full stop. Full stop. 3 Kyle, the learned council has very fairly submitted that in the meantime, the division bench of this court, by following the aforesaid principle, has held that a review will not be maintainable. Full stop, para. Sri Sandila, the learned counsel for the respondents, has submitted that since the subsequent order of the Supreme Court has clearly laid down the principle, comma, the present petition would not be maintainable and is liable to be dismissed. Full stop, para. After considering the facts and circumstances, and also taking into view the subsequent orders passed by the Honorable Supreme Court in dated 4/11/2025, comma, at this stage, comma, the Sri Kyle has submitted, has informed this court that apart from the order dated 4/11/2025, comma, another order on the similar lines was passed earlier on 12/2/2025 in review petition within bracket C 341 of 2025. Full stop, para. Considering the principles laid down by the Honorable Supreme Court in the subsequent orders dated 12/2/2025 and 4/11/2025, comma, this court is of the view that the present application for review would not be maintainable, and accordingly, the same stands dismissed. You could have brought it, we could have, tomorrow you bring it. Give a mention memo and the same lines. Okay. Single bench hobo pore. Kalli kane koise. Adi dipo kalli list korbo. You try to give a mention memo today, but you have to no, other side is but you have to coordinate with the office to get those, okay? Yes. You can make a mention tomorrow, we'll allow it, but you can coordinate the office, take out the files in advance, okay?